Good afternoon, everybody, and thank you for joining us on today's webinar. My name is Brett Barnett. I'm joined by my colleague, David Pivnik. We're here today to talk about hospitals and physicians and their relationship to the False Claims Act and current False Claims Act developments. Quick background about David and myself. We're both attorneys in McGuire Woods' Chicago office. We both focus our practices exclusively on healthcare litigation and devote the majority of our practices to dealing with False Claims Act issues and other issues relating to fraud and abuse in both the private and government sphere. We're looking forward to a lively webinar today and hope that you guys will submit any questions that you have. We'll try to take those questions as they're submitted, but feel free to leave them towards the end if you prefer to do it that way. I wanted to start off today's webinar by, putting a lay of the land on the statistics of the False Claims Act recoveries and just the environment of enforcement that we're dealing with right now. David, could you talk about that for a little bit?
Absolutely. Thanks, Brad, and appreciate the introduction, and thank you, everyone, for joining us today. Hopefully you'll all find this informative. I think a lot of, I'm looking at the attendee list on the side of my screen as we're talking, and I see some familiar names and some people that I know, and I suspect many of you, whether you've heard it from me in a prior presentation or just generally from your work, know the numbers are pretty staggering in connection with the False Claims Act, and they continue to be staggering, and particularly in healthcare. So I don't want to spend too much time on them, but just looking at it, 2017, again, nearly $4 billion in government recovery under, in connection with civil fraud. And one of the things that's interesting there is, this is basically 5 years in a row now where the government has recovered $3.5 billion in a year in each of those years in connection with civil fraud recoveries. And that's kind of staggering, both in terms of the overall sum of the number, but also because each of those years are the 5 highest years ever. So the government is continually putting up top 5 years. They haven't hit the high watermark of $4.9 billion again in the last couple of years, but once again, 2018 looks like it's going to shape up in that same vicinity. And I think we can reasonably expect, based on the recoveries that are being garnered, that the government's going to continue to devote its resources to fraud enforcement, because there's reasons from a compliance and government relations standpoint that they want to root out fraud and make sure they emphasize enforcement from that standpoint. But when you factor in the overwhelming recoveries that they're getting as well, there's obviously some very significant financial motivators to do that. Of note on this, healthcare continues to be a big component. I think over each of those 5 years, healthcare has made up more than 60% of the government dollars in recovery. And that's come from a wide cross-section of players in the healthcare space. Some of it's come from many of the payers, insurance companies. Dialysis companies, particularly DaVita, have made up a huge component of that in several of the years, because they've had a handful of 9-digit settlements that they've entered into. Pharmaceutical and medical device companies have been a big target. But in the last couple of years, we've seen a lot more activity for hospitals and health systems and physicians. And we've seen it both in connection with civil litigation under the False Claims Act, but also, frankly, criminal investigations that tend to have, different and more serious penalties, not just the financial consequences, but also jail time and other impacts on the entities and individuals in question. So, again, we've sort of showed the $22 billion in healthcare recovery over basically the last 9 years. To my mind, actually seems less impressive when you think about the fact that it's been about $17 billion in the last 5. So the numbers, though, do continue to be staggering. We don't expect that to change. And the new FCA suits that were filed in 2017 sort of reflects that. Key TAM suits are continuing to be much higher than they were in terms of numbers filed each year a decade ago. 10 years ago in 2008, 2009, the numbers were closer to 350 to 450. It's gotten as high as 756, I think, is the high year in the last couple. So 674 whistleblower suits last year is certainly not the high watermark, but at the same time, it also continues to show that the trend is for these cases to be brought, that the numbers are going to be significant, and that we expect to continue to see a lot more activity in this space. The other part of that is I think the government is becoming much more active on its own front here. The government is intervening far more often than it used to The percentage of cases in which the government intervenes has only gone up slightly over the last decade, from approximately 21% to a shade under 25%. But when you consider that the number of whistleblower filings or qui tam filings has virtually doubled over the last decade, that effectively means the government is intervening twice as often as it did previously. So that's a pretty significant increase. But the government's also taking a much more active role in conducting its own investigations and running its own investigations. The government is being incredibly vigorous and careful in analyzing the numbers, looking for statistics and trying to figure out, if they can spot outliers and potential fraud or other wrongdoing based on it. And those statistical analyses are leading to investigations. And that doesn't always result necessarily in penalties or fines or it going anywhere, but the government's certainly using big data and statistical analysis to really monitor things right now and figure out where there might be outliers or potentially problematic actors, and then pursuing those where appropriate. So I think that's another sort of consequence here. And again, just looking at the percentage, healthcare continues to be the majority of the action. So other industries like the defense industry and the mortgage industry are number 2 and 3 respectively, and they both represent a healthy proportion, but combined they're about half of the healthcare cases. And then in terms of looking at the recovery, the one other thing we wanted to touch on with the numbers, it's an interesting dynamic, and it may end up being that this was more of a fluke in 1 year, but the government historically, as I just noted, the government's going to intervene in 1 out of 4 or 1 out of 5 cases. That's sort of the range, 20 to 25% of the time the government intervenes. That's what we're looking at. But typically, notwithstanding that very slight fraction where they're intervening, the government tends to recover 90% plus, sometimes 95% plus of its overall fraud recoveries from cases in which it intervenes, which, there's a lot of reasons for that. The government gets to choose its cases, so it gets to pick the best cases, the biggest cases, strongest, etc. But I think it also reflected that there was an old belief, and I think it was a much truer belief 5 years ago than today, that when a whistleblower, if the government declined intervention, the whistleblower would often drop the case. In my experience, I think more often than not, and by a fairly heavy margin, frankly, more often than not, the whistleblower proceeds with the case. But certainly in the last couple of years, there's been a couple of cases we've worked on where the whistleblower did not proceed, and in a couple of those we were able to take sort of affirmative steps with, in the discussions we'd had with the government and also with Relators Council to push them away. But I think as a general rule of thumb, the relator bar, the qui tam bar, is much more sophisticated than it was several years ago and is becoming progressively more so. It's a well-organized bar, and there's frankly a lot of good, talented attorneys who are doing this work and who would obviously prefer that the government intervenes for, I think, obvious reasons. It makes their case have a lot more value, but ultimately that are willing to pursue it otherwise. And we've sort of laid out a couple of the key concepts here. I mean, from what I've seen from cases that I've worked with and frankly from presentations that I've done with assistant U.S. attorneys from around the country, patient harm is always going to be a big consideration. They want to root out patient harm, and if that's a factor in the case, that's going to be a very compelling factor that's going to be more likely to prompt the government to act than not. They're also looking to identify, how cut and dried this is. It's a lot easier from a time and resources standpoint to pursue, for example, a kickback case where ultimately the goal is going to be to prove that a kickback was paid, and then they're going to argue that every claim after that kickback was paid is therefore tainted. That's going to be much more compelling and simple, frankly, from a proof standpoint than having to go, item by item on a medical necessity case or things of that nature. And from a company standpoint, to my mind, because of the numbers and how things ultimately play out, depending on whether or not the government intervenes, I think it's absolutely paramount to get in front of things, to be able to have a discussion with the government where you're laying out in advance, if there is an argument to be laid out, we're a good company, here's what our compliance plan looks like, here's why we think there's nothing wrong and there's no issue, or if there is a potential issue, being able to lay out, here's why we think this issue is minor or doesn't reflect that we're a bad company and rather reflects that we may have done things imperfectly. So any settlement or resolution moving forward should reflect that, or notwithstanding a potential mistake, the government should intervene. So I think having those discussions, trying to keep that in mind, is an important aspect of the analysis.
Thank you very much, David. And switching gears a little bit, wanted to talk about some of the main theories that we're seeing relators and the government advance in order to make these great recoveries that David just discussed. As I'm sure anyone that practices in the sphere knows, the recent name of the game has been implied certification. It is the prevailing theory that we see come across our desks in the majority of the False Claims Act cases that we work on. For those that don't know, or for those that just look for a quick primer on this, 2 years ago, the Supreme Court handed down an opinion in the case it's called Escobar. And the Escobar case had two things that were at issue. First, whether the implied certification theory of liability was valid. Second, what were the standards for implied certification? Implied certification, in short, is the theory that anytime a healthcare provider submits a claim for reimbursement to a government healthcare program, they are impliedly certifying that they are in compliance with all applicable statutes and regulations. This is in contrast to an express certification of where something on the face of the claim is facially fraudulent or inaccurate or deliberately inaccurate. And so there was a circuit split upon whether the implied certification theory of liability was valid. In Escobar, the Supreme Court said, yes, it is. It is a valid theory of liability. And the initial reaction to that from the defense bar was, okay, well, that's not a great result for the defense bar because that allows in just a sea mass of claims that were potentially going to be dormant or be rejected. The second part of the government's holding, though, has ultimately turned out, at least in the first couple of years, to be defense-leaning and defense-favorable. It is that in order for a claim to be viable under the implied certification theory of liability, it needs to be material. It needs to be material to the government's payment decision. The way that some courts have looked at this is that but for that misrepresentation, the government would not have paid the claim. And so defendants and courts over the past 2 years have really latched on to this exacting and demanding standard that the Supreme Court has imposed on materiality and have used it as an aggressive defense to defeat a lot of False Claims Act cases that are based off of regulatory violations, breaches of contract, and anything that the relator or the government is unable to either allege at the motion to dismiss stage or prove through factual evidence at the summary judgment stage was a material decision to the government's payment, or material to the government's payment decision. That's the main theory of liability that we're seeing. It has a broad application to hospitals and to physician groups. We're also, though, still seeing a number of just the more typical bread and butter claims based off of upcoding, fraudulent claims, and then another thing that we wanted to also discuss is that there is an uptick in anti-kickback-based cases. Relators and the government alike both love kickback cases because it makes their damages theory so much easier, or their damages so much easier to prove. The logic behind that is that whereas with a coding FCA case, you typically need to either prove that each claim was fraudulent or that a statistically valid sample of those claims was fraudulent. With a kickback issue, the government's prevailing view, and the courts seem to be in agreement with this, is that the entire relationship is fraudulent and tainted and therefore subject to reimbursement. Put differently, anytime a claim has been submitted to the government for reimbursement under a kickback or pursuant to a kickback relationship, it is subject to a False Claims Act recovery and treble damages. The last thing that I wanted to pick up on is that we're starting to see an uptick in coordinated efforts between private payers and the federal government in fraud and abuse cases. And so Not that there's the same standard of liability for False Claims Act as there is for fraud in a private civil dispute, but we're seeing a lot of insurance companies work hand in hand with the federal government, where where the insurance company they've either identified a fraudster, or the federal government has identified a fraudster and gone to a private insurance company to see what activity they have from this payer or from this provider, and they're using each other's resources and tools to try to ferret out what they refer to as just the bad guys colloquially, and trying to root these guys out of the system as quickly and as aggressively as possible. With that, I wanted to turn it back over to David to talk about one other area that we're starting to see a giant amount of activity.
Thanks, Brett. And, opioids is obviously sort of, as a general topic, the opioid abuse crisis is getting a lot of attention from a ton of different angles in the media these days, and is clearly a focal point for the government from a lot of different perspectives. And I think from a fraud enforcement standpoint, it's getting a lot of attention as well. And one of the things that I think is really interesting about it is there's a lot of different angles or theories of liability here that exist, and that the government is able to sort of utilize as part of its enforcement mechanism. And so I wanted to talk through those, but I think opioids is a great example of a situation where the government can sort of get excited, and they might take umbrage at me using that term, but I think they can get a little bit excited about it, because clearly rooting out the opioid crisis and doing that is good from a national health perspective. It's not just about running up the money or a good ROI on fraud enforcement. It also really does go directly to patient harm and getting drugs off the street, so to speak. But where I think from a litigator's standpoint, and particularly from a defense attorney's standpoint, I think it's interesting is we've seen a lot of different theories of liability and a lot of different types of cases being pursued in this area. So, some of them are sort of what you might think of as obvious. If you're a physician selling prescription pads or things of that nature, or selling prescriptions, come to my office, pay me $150 for an appointment, and I'll just write you a prescription for whatever you want. I think that's sort of clearly a problem, and something that anyone could recognize the risk. Where I think it becomes a little bit more interesting is some of the other theories that we're seeing, where I think providers are getting into these issues by frankly not being very careful or really thinking things through. So overprescribing, I'm not necessarily even referring here to just saying here's 1,000 on a prescription, but what we're seeing is instances where providers are giving too many refills. And some of the physicians, are basically trying to explain it as saying, we don't want to have to make the patient come in, et cetera. But there's obviously risk there. So giving automatic refills, prescribing too many, and not in extremes like, the 1,000 that I just referred to. But we're seeing a lot of issues on that front. And I think it's causing providers to, in some ways, the more prudent providers to cut the other way and take some, precautions to make sure that what they are prescribing is truly appropriate for the patients. That should go without saying, but also that the patients who are obtaining these prescriptions are using them and using them as intended. And so we're seeing, more clients that are deciding to go to more frequent urine drug screens and things of that nature to make sure that the right drugs are in the patient system and things that, so that they can sort of control that. And doing that monitoring a little bit more often, is a way of exercising control over it, but similarly making the patients come in, meeting with your patients, actually going over, as you should be, on a case-by-case basis before making a prescription is helpful. And I think it sort of gives a motivation here to take some of the laziness out of it, where you might otherwise be saying, I don't need to see you again, here's a prescription. That's not the intended treatment, and I think that helps. The other two that I'll just touch on briefly, kickbacks are clearly a concern here, and a place where we've seen issues with the opioid, where physicians are getting paid to prescribe, and then marketing companies are the one that I think is sort of the stickier and trickier area, where we're seeing a lot of cases, frankly, in the marketing space, where marketing companies are serving as a liaison between physicians and the drug manufacturers. And oftentimes that's compounded drugs that are at issue, but we're seeing in other contexts as well. And I think there needs to really be an analysis of, if the physician is getting money, what is the physician getting paid for? And is that payment appropriate, and can it be justified? And I think in a lot of these cases, that's part of the challenge. I think the other part is what services is the marketing company providing. I mean, ideally, it's not, going to the physician unless there's a reason for that. And for the marketing company, if it's just a matter of saying, we introduced you to X physician and now you're getting a bunch of prescriptions, that's going to be a lot harder to justify versus actual work being done in the marketing space that's going to be able to be used. So I think that's all stuff that's being considered, and I think particularly because of the focus on opioids, that's going to continue to be something that's examined, on a going forward basis in a fairly robust manner.
Thank you, David. And so now we've covered the statistical analysis of what the False Claims Act recoveries look like. We've looked at what the hotbeds of litigation activity are. Wanted to shift gears again and look at what the DOJ's positions are and what they're sending out to the public as, here are the things that we care about, here are the things that we don't care about, here's how we are going to proceed in our False Claims Act litigation. This is all very important, it's all very helpful to us, and as members of the FCA Defense Bar, it really allows us to create and navigate in accordance with what we think the government is looking for and the defenses that we think are going to be viable in response to the government's purview. And so the first memo that I wanted to discuss came out, it's 3 years ago now. It is a memo that was authored by Sally Yates, who is then the Deputy Attorney General. It's called the Yates Memo, colloquially, and there are 6 points to the Yates Memo that talked about how they're going to deal with fraud and abuse cases. The 3 of them that I really wanted to focus on today are individual liability, cooperation credit, and criminal liability. Taking those in order, the Yates Memo announced that the government is no longer going to allow the individuals that they believe are spearheading the wrongdoing for or on behalf of the company to absolve themselves of liability or escape any financial penalties based off the fact that they simply were acting for and on behalf of their company. No, the government has said that they are going to hold the individuals that were accountable for the fraud in the wrong. They are going to make them liable. They are going to make them signatories to any settlement agreement. They are going to make them pay for it, in order to put it in a blunt phrasing. They also believe that in doing so, this is going to deter future conduct, that it will stop the pervasiveness of fraud and abuse because individuals will know that they now have skin in the game. The second issue, and I can cover this briefly, is that in order to get cooperation credit as part of any settlement or resolution with the government, the entity needs to be full, frank, and forthcoming in its disclosures. It cannot hide the ball. It cannot try to absolve any of the individuals that were involved in the fraud from wrongdoing. It needs to lay its cards on the table and not play cute with any of the facts. In our own practice and experience, this is something that the government obviously takes very seriously. They do reward forthrightness. They do allow for, I think, simpler discussions, simpler negotiations, if that's the end game, to take place. If you are being forthright and disclosing everything that needs to be disclosed, and coming to the government when you've identified a problem, and being the affirmative party on that, and not just hoping that the government is going to miss an issue or not see a document, because that's just not going to happen. And so giving the government the benefit of the doubt and going to them to explain, yes, this happened, but it was an isolated incident. This is how we're doing. This is how we're remedying it. This is what we're doing to stop this from happening again. That is all stuff that the government takes into consideration when it's working towards a resolution. The 2 more recent memos both were issued in January this year. The first that I'll talk about is the Granston memo, and then we'll skip to the Brand memo next. The Granston memo is a giant boon for the FCA Defense Bar, hopefully. We haven't seen much activity in where AUSA has announced that they're going to take action relying on the Granson memo, but it's something that is certainly going to be part of any presentations that we make to the government in the future, where we're dealing with what we believe to be meritless FCA litigation. And so, in short, the Granson memo said that there are 7 different issues that they're going to look at in evaluating qui tam cases and whether they should intervene. The most important aspect of that, from our perspective, is that the government has said that it will exercise its authority to dismiss litigation outright in cases that they believe are frivolous. And so this is going to be different than what they've done in the past, in most instances in which they will simply decline to intervene, and then they will allow the qui tam relator to proceed while the government just remains as a monitor of the litigation. Here, if they believe that the False Claims Act litigation itself is meritless or without basis, the government will exercise its discretion to affirmatively dismiss the litigation outright. This is obviously something that I know that the FDA Defense Bar and David and myself are going to be really relying on and using as part of our presentations to the government when they're making their intervention decisions and when we're making our pitch to why they shouldn't intervene or why there's nothing to see here with the litigation, is that it should be affirmatively dismissed and not just a declination of intervention. The last memo I want to talk about is referred to as the Brand memo, another benefit to the FCA Defense Bar. In short, it says that the government cannot rely on sub-regulatory guidance in order to prove liability under the FCA. And so this means that any opinion letters, any guidance to regulated entities, anything that has not gone through the notice and comment provision and is not an actual regulation statute or theory of liability developed through case law cannot be used in and of itself to establish liability. There had been splits before amongst the appellate courts as to whether sub-regulatory guidance could be used to establish liability, and now the DOJ has taken the position that they will not be using that in their own prosecution of False Claims Act cases. It's another thing that we will be using, Defense Bar will be able to use in its pitches to the government where they're trying to establish a novel or creative theory of liability that doesn't necessarily have regulatory support, but it's been talked about in secondary sources or in published guidance. You're not going to be able to prove your case because there's nothing that actually prohibits the conduct that's described herein. It's just a position paper of a DOJ attorney, which cannot be used as proof for establishing liability. So we've seen a lot of developments over the past 3 years. The DOJ is starting to help give some more guidance on a more regular basis, it seems like, on what they're interested in under the False Claims Act, what theories of liability they care about, the areas in industry that they care about, and what types of cases that they will say are not worth being pursued in court outright. With that, I wanted to switch topics once again, and we're going to start talking about internal investigations and ongoing compliance efforts. David, could you kick off that conversation?
Sure, absolutely. And, I think it's important, particularly, again, I think part of the focus of this webinar was on the provider side and for hospitals, health systems, and physicians. And I think having a robust compliance program, I would hope for everyone on the call, sort of is one of those no-brainer, goes without saying items that, while the words just came out of my mouth, everyone, nods their head and knows that, in advance, and it's a minor point. I think where it becomes more interesting is figuring out how to utilize that and move forward. And one of the things I've, taken to recently is figuring out with clients, do you want to have training in terms of what happens if the government comes knocking? Because, in the healthcare space at this point, it is, unfortunately becoming common enough to get served with a subpoena or CID, even if it might be just as a witness, that, having people who are going to respond appropriately, I think becomes important. And I always tell a story of, I had a client who is a physician who had, a couple of FBI agents show up to survey subpoena, at this point about 6 years ago. And this is an old story, but it continues to resonate for me because, one of the things he said to them, they got there and he believed he had nothing to hide. And in this instance, actually, they were showing up, frankly, as he was a witness in their investigation. They were looking into a device company. But he looked at them, and one of the concerns was the volume of procedures that he was using of this other device. And he said to them, just sit in my office. I'm going to go perform a procedure on a patient. I'll be back in 5 minutes or less. And the message, putting aside that he didn't need to be in a rush to talk to the FBI agents who had come to serve him that day, but the message that he's giving them is also, hey, you're concerned about the medical device company based on volumes and how they're handling their relationship with physicians. But look at me, I do my cases in 5 minutes or less. And I think if you're doing a procedure in 5 minutes or less as a general statement, that might attract attention. And I think having that interaction, to me, it always sort of crystallized the notion of you need to be prepared for these things. You need to think them through. You need to understand what your rights are and what your obligations are, and recognize that you don't need to invite the government who's process server in effectively. I know that they're more than a process server, but you don't need to invite them in and have a discussion on the spot that day. That's not an obligation. So, I mean, there's a few different purposes, and we're going to talk about those in more detail in a couple of slides, but I want to talk a little bit now about some of the key steps and the thought process to go through. And I mean, one of the first things to recognize in terms of best practices, I'm going to take the second thing first, which is, we have outside counsel on here. It's not a self-serving statement on our part. There are certainly investigations that can and appropriately are handled by in-house attorneys that don't require outside counsel. However, there are going to be instances where I think having outside counsel becomes very important, and that could be a bunch of different categories. But, I think if there's going to be a lot of interaction with the government, there's a lot of benefit of having outside counsel involved, particularly because likely you can have outside counsel who has familiarity with the DOJ or has familiarity in similar cases and can leverage that. Similarly, if any of the conduct at issue ran through in-house counsel's office or the general counsel, that doesn't mean they did anything wrong, but it doesn't make sense for them to be leading an internal investigation themselves. So I think figuring out generally who the right stakeholders are internally, who is the person that needs to get the ultimate report, and who do we need to treat as witnesses as part of the investigation versus people who are going to be receiving information is important. And similarly, and this goes to outside counsel as well, if outside counsel was involved in the underlying decision, you may want to have a different attorney serving as outside counsel in connection with conducting the investigation and dealing with the government. And I say you might, but frankly, I'd recommend that. Timing and duration is always a tricky question because I have clients who constantly are saying to me, we want to do this and we want to do it right, but we want to do it immediately, get it done now. And there's always, my first word of caution is, I can move as quickly as you want me to move, but we need to do things the right way if we're going to do them. It doesn't make sense to do an investigation halfway. You're going to just spend money. You're not going to get to the bottom of it. And most importantly, if the goal is actually to fix the problem or to go and interface with the government, you don't want to do things halfway. I don't want to be in a presentation with the government where I think I know everything and it turns out I don't. We're going to end up doing, complete disservice to the client, and I'm going to lose credibility with the government. So it's just going to be a step backwards. So, my view on this is always the attorneys can move as quickly as possible, but I think everyone needs to recognize if there's an internal investigation with a serious issue, and moreover, more importantly, if there's a civil investigative demand and the government is already involved, we don't have complete control of the time frame. There is no easy button for me to push that's going to make the DOJ take a meeting with me on, 2 weeks, 2 weeks from the service of the CID, and we can put this to bed. It just doesn't work like that. The DOJ is incredibly receptive to taking those meetings. I've never had an issue getting it scheduled and going in, but they're not going to meet with me on a piecemeal basis where I come in every 2 weeks to answer questions because it wasn't complete. I'm going to get one bite at the apple, maybe two. I want to make sure that we're going to take the best foot. So I think timing and duration, we want to set out a roadmap at the beginning, figure out timing that's realistic for the internal work, figure out a timing and work with the government so that we're very transparent in terms of what it looks like from a government standpoint. But I think we need to be realistic about the deadlines. The witnesses and documents aspect is the other thing that's always important and sort of a touchy subject because, from my standpoint, we want to be able to run effective search terms and get our hands on the necessary documents to review at the outset. And that usually means I want to sit down with a few of the key custodians first and do a non-substantive interview, just talking about where are the documents, what documents do you have, where are they located, and then gather those documents before we're digging in on the substance and conducting interviews. And that means we're going to be meeting with several people, multiple times. But I think each use of their time is going to be more effective than if we didn't do it that way. And I think just as importantly, it's going to make the investigation as a whole far more effective because we're going to get to the bottom of things. So doing that first and then coming in with substantive interviews when we've got the documents lined up is important. It'll also help us identify who truly needs to be part of the substantive interviews later because, we always end up starting with a long list of potential people with information. And then as we narrow it down and get into the work, it becomes very clear that many of those people really didn't have any pertinent information, or we don't need to interview them. So, the biggest takeaway to me on all of this, the number one best practice is you have to have a plan. You have to figure out what a realistic timetable looks like. You have to figure out who the right custodians are, who the witnesses are, who the right stakeholders are internally, who's going to run the investigation, and then work through it in an orderly fashion. And the other part of it is I think you really need to do all of that without having a preset agenda. There's no upside. It doesn't help to look to confirm an issue. It doesn't help to look to prove that there is no issue because you're going to miss things if you do that. The goal needs to be we need to figure out what's there so that we can address it, or we need to figure out there's nothing there, but we don't know yet, and we're not going to know until we've done this and done it appropriately. Moving on and talking about sort of some of the considerations, and to me these are less consideration in terms of how to handle it, which I think I just talked through, but this is a little bit more in terms of what the upside is of doing it. And I think there's a lot of upside, and we've also listed some cons. I want to start with actually the last con, which is, drawing attention to potential issues, because this is one where, I debate, and notwithstanding this is our presentation, but I think the placement of this as a con is always sort of a tricky one because on the one hand, you don't want to draw attention to potential issues, but on the other, that is kind of the point of the investigation, is if you've got potential issues, by view, across the board every time, I think I would actually move this to a pro as we're talking about it. At the end of the day, I'd rather know that an issue exists. You can always choose to make a decision afterwards that you don't think it's a false claims issue, you don't think it's a true compliance issue, it's just something we're going to correct. There might be different ways of treating an issue, but a company gains nothing by having an issue that exists and isn't brought to light. You're always better to know what's there and figure out the best pathway forward to correct that situation than to simply not know what's going on when the liability is still going to be sitting there festering. It doesn't, not knowing about it, you may not trigger an overpayment, obligation to return that money, but the existence of the false claim or the fraud is still going to be there. So other than trying to wait out a clock on a statute of limitations, there's not a lot of upside. In terms of the more obvious, pros, I always think the biggest one is demonstrating top to bottom in the organization that we care about these issues, that we take compliance seriously. When things are brought to our attention, we're going to get to it, and we're going to figure out what's wrong, and we'll figure out appropriate steps forward, whether that's new training, refunding money, a self-disclosure. There's a huge array of options that are going to come into play, but I think demonstrating across the organization that we take things seriously, we want to do the right thing, we want to be compliant is going to be helpful. And I think that sort of goes forward if you do have a case come up as well, because it is much better to be able to explain to the government, look, here's what our compliance program looks like. Here's, how we missed an issue potentially. Here's how we fixed it. Here's what we did to identify that. Here's how we're going to make sure it's never happened again. All of those steps are going to bolster your credibility. And, I recently, a couple months ago, we settled a false claims case where the client had great concern about the possibility of a corporate integrity agreement. And in my opinion, I didn't think it was appropriate in this case because I think the conduct came about innocently. Not just as an advocate for them, but I truly believe that. But it was very helpful when I had discussions with the Office of Counsel for the Inspector General to be able to say to them, look, we sort of walked them through. Here's what the compliance plan looks like. Here's how they've done training on compliance. Here's how they've refreshed it. Here's the periods where they're doing those things. And here's what happened in this limited instance and why we don't think, this demonstrates, systematic failure so much as one or two employees due to a couple unique circumstances made a mistake. And ultimately we didn't have to enter into it. The client didn't have to enter into a CIA. And so I think that's helpful as well. And then again, there's other benefits in terms of figuring out what the root cause of the issue is and preventing it from happening again. The cons, I mean, the most obvious is it is something that is going to take many business people's time. It's going to take a lot of money for the company. It's going to be a distraction. There isn't really a way to avoid that if you're doing an effective internal investigation. It's always just part of the nature of the beast, and we can always structure things to minimize the cost and to minimize the inconvenience, but that's certainly part of the analysis to go through. And then I won't spend a ton of time on this last slide on the internal investigation angle because I think it's sort of been encompassed, but I think there are a lot of reasons to do this. Some of it is, again, if you know you got a CID coming in, I'm a huge believer that it makes a lot of sense to conduct an internal investigation and not just be, responding to the documents. I mean, you have an affirmative obligation to produce the requested documents, and that's going to exist regardless. But I think it's also very important to go through and figure out, do we have a problem here? To me, there's a big difference between simply, responding to the government and letting the chips fall where they may, which I think is pretty ill-advised, versus going in, figuring out what problems exist, and then going out and figuring out how to position it with the government to move forward. And again, that doesn't mean telling the government, there's nothing to see here, you've got it all wrong, let us go. That may mean going in and figuring out a settlement. The internal complaints is where I want to spend just a little bit of time talking, because to me, that's the most important category. I've said many times that, I view the world right now as there's three types of whistleblowers. Some of them, are in it for the money. They don't really care about anything else. They think there's a buck to be made, and they're going to go out and try and make that buck. Some of them, hate the company. They're a terminated employee. They had a bad experience. They hated their boss. Whatever it might have been, they're bitter and disgruntled, and that's that. You can't do anything about those two categories, so it is what it is. The third category, though, and I've seen this come up in multiple cases, is someone who is just honest to goodness concerned about the company. They like the company. They don't have any animosity. They're not just trying to make a buck, but they really do believe that the company could be doing things better from a compliance standpoint, and they're concerned, and they feel like when they raise those concerns internally, they're simply not being heard. And that, to me, that category, and it's probably the minority, probably even a distinct minority, but I think that's the category that you really need to speak to and think about when you're addressing these issues. You get an internal complaint, it is very easy to figure out ways, even if you've looked at it and really confirmed that someone was just wrong, that they missed the mark with their complaint. Even if that's the case, it never hurts to renew some compliance training or to do things of that nature, update a policy and procedure to make sure that it is very clear why this, that this won't happen again and that this concern is being addressed. Make sure you sit down with the person. If it's an anonymous complaint, it's an anonymous complaint. But if you know who raised it, you don't need to keep them informed with every aspect of the investigation, and there's a lot of good reasons not to. But sitting down and saying, look, we wanted to talk to you about this. We take the concern very seriously. Here's what we're finding. Here's what the law says. Here's where we're at. We think there isn't an issue here. It really, to me, there's a lot of benefit to having those discussions, and I think some of these concerns can be addressed and put to bed before they become a much more costly, public, and, ugly issue. So, I always encourage people to take those concerns very seriously and to try and be active on them. And with that, I know I've taken a long time on the internal investigations. I'll turn it back to Brett.
Thanks, David. And wanted to cover, I guess it'd be related issues, but it's the order and sequencing and putting a game plan in place in how to conduct an internal investigation so that you're not spending time spinning your wheels, missing key steps, not taking a full throttled approach to making sure that you've got all of your ducks in a row is of a key and critical importance in conducting an internal investigation. And so while there's no intention or desire for me to walk through each of these bullet points that are in the slides in front of you, this is a typical sequencing from which I know that David and I will look at an internal investigation, and the steps, a lot of these will be taking place simultaneously. And so just to highlight them, it's really at the outset, It's getting all of the procedural niceties tucked away, making sure that we have a good scope of who should be interviewed, both as a custodial witness and a substantive witness, figuring out who the lead point of contact at the DOJ is so that we can reach out to them, let them know that we represent the company that's been issued the subpoena, the CID, or that's for some reason under investigation, and then opening that line of communication with the government. And then it's starting the investigation itself. And so typically the way that we conduct an investigation, there's not necessarily a right or wrong approach. We've just found this way to be the most cost-effective and ability to drive the best results for the client, both in terms of a substantive outcome and in terms of us learning information in an expedient nature, is that you identify key custodians of documents. Those are typically will be spread across a number of departments within the company, and we figure out, or that are obviously pertinent to the investigation, and we figure out what documents they have that would help us learn about the case, what documents they have that will be responsive to the subpoena or CID that was issued, and we leave the interviews at that. They're just about gathering and collecting documents. And we'll conduct these investigations and these interviews typically in 1 to 2 days. They usually don't take more than 30 to 45 minutes, and we work through a series of questions to find out what documents they have. And where there are hard copy documents that are not based off of an email server or non-electronic, we will actually go and collect them from the interviewee at that time so that we can get our review going as fast as possible. From there, it typically moves into a document review process where we're producing documents on a rolling basis to the government, and we're learning about the case, and we're learning who the key players in this action are, who the individuals are that we should be interviewing on this, and learning the sequencing and ordering of the interviews of who should be interviewed is also important, because you don't want to interview the key witnesses first, because you're going to learn more and more information about the case as you continue and as you conduct those preliminary witness interviews. Some of the other key considerations that we like to make sure that you put into place is that where it is an internal whistleblower and you have a good idea for who the whistleblower is, either through just your own deductions or through it just being well known and that it was a public complaint, there are a number of considerations that you should take into place. And while this is all going to be specific to the jurisdiction, and it should all be researched ahead of time in advance and make sure that what you're doing comports with what the law of that jurisdiction is, there are a couple things that you can do to I guess, expedite and make the investigation a little bit more effective. One, you should always limit the investigation and disclosing the investigation to the personnel that need to know it. And that's being done primarily, in large part, to make sure that you're preserving the attorney-client privilege. When outside counsel like McGuire Woods is brought in, we identify the key client contacts. We talk with them about our thought process. We'll be working with them about our conversations with the government. And the conversation should typically be limited to that first channel and then possibly one more downstream. But after that, we have concerns that you can start waiving inadvertently the attorney-client privilege, where our information is being relayed to further and further down the stream, or to third parties or to non-parties. And that's obviously something that most companies want to avoid. The second thing that we should always remember, and it's a very hard thing to do in this day and age, is that we should limit email communications when conducting internal investigations. I know it's the preferred way of communicating for most people. It's how I communicate with most people all day long. But emails that are not privileged are discoverable in most instances. And we always have bad emails in every case, but we want to minimize those emails. We want to minimize anything that would make the company potentially look and be cast in a bad light. Also, emails are very easy to be forwarded on to parties and individuals that you don't want it to be forwarded on to. So we always prefer that communications be oral, that the records not be kept or maintained unnecessarily. And by that, I mean records of the conversation not kept unnecessarily. You obviously need to keep and maintain all written records. We can't get rid of anything like that. The third point that I want to bring up is you want to look at, when you're conducting an interview of a whistleblower, like David had mentioned, what was their impetus for reporting? Who are their supervisors? And what actions have we taken to remedy this before the investigation has begun? The fourth consideration is are you going to be interviewing the whistleblower? A lot of the times companies want to steer clear of this because they're afraid that there's going to be a retaliation claim, or they're afraid that the whistleblower is not going to comply with the investigation. And so while this is not necessarily the law in every jurisdiction, the prevailing majority of courts have found that you can direct a whistleblowing employee to participate in an internal investigation and to participate in witness interviews. On a related note, whistleblowers do not have in most states do not have a statutory and do not have a constitutional right to have their attorneys present at the interview. This is a matter of company policy usually, but there's typically no statutory or constitutional obligation for an employee to have its attorney present at the interview. A couple other things to take into consideration when conducting those interviews themselves are where are you going to be conducting them, whether you have HR present, whether you have in-house counsel present, and these are all typically just decisions that are going to be fluid in nature and are going to be dependent on the individual facts of the case. The general rule of thumb that we give, though, is that it should be whatever you think will allow that individual witness or interview to be the most comfortable, because the whole purpose of the internal investigation, or the primary purpose of the internal investigation, is to gather facts so that we can figure out how to make the most effective presentation to the government. And so whatever you can do to further the witness's comfort so that they can be forthcoming and be as honest as they will be in this kind of intense situation, the better. With that, I know that we're coming up on an hour. Wanted to turn it back over to David just to close out on some ongoing monitoring discussions.
Sure, and before I get there, we have had one question come in so far from the audience, and obviously if there are any others, we're going to try and wrap this up in a couple minutes, but feel free to send them, or obviously, please don't hesitate to reach out to Brett or myself afterwards. We're more than happy to discuss, confidentially and handle any questions that arise out of the presentation or generally. One of the questions we got is if it makes sense to always effectively have outside counsel conducting the internal investigation for purposes of upjohn warnings and attorney-client privilege, things of that nature. In-house counsel, it's a sticky from a privilege standpoint, and I've actually had multiple cases over the last couple of years where the DOJ has taken what I view as some fairly aggressive positions in terms of the extent of the privilege. My view is if the attorney, and I think the case law supports this, is if an in-house attorney is providing, advice as a lawyer as compared to just being involved in business operations, because we recognize that in-house counsel and courts have recognized in-house counsel wear both hats, a legal and a business hat. I think it's important, and I think it is privileged. And so I think if the investigation lends itself to being conducted internally, and to me that typically means the government's not involved at that point in time, and there's not a particular reason to believe the government's going to be involved later. If it is, I think it makes a lot of sense to go to outside counsel. If the scope of it is relatively controlled, if you're able to do it without impacting or treading upon the existing relationships and those dynamics aren't going to play a role, I think it can be done. I think it can be made clear that the individual attorney, even if they're an in-house attorney, is not representing the individual employee as an individual, that they work for the company, not the individual, and the privilege can be maintained. I do think best practices is typically, is to have outside counsel handle it, but I don't think that necessarily needs to be a per se rule. Because we're real short on time, I just want to touch on a couple things briefly. So on the slide that's up, I'll skip the best practices part because I think we've covered a lot of that. I do want to talk about audits because, again, particularly for some of our hospital and health system clients that I see are on the line, and for any provider clients, I think the concept of doing recurrent auditing, and that could be, a couple charts every week, a couple charts every month, annual audits. Some auditing function, I think, is incredibly important. I think it's important to make sure that, your physicians and your billers are coding correctly and that claims are being submitted appropriately. I think it's important because if something goes wrong, you're going to be able to identify it before, so that you might catch it when it's a 100 claim issue instead of a 10,000 claim issue because it's been going on unchecked for years. And I think most importantly, honestly, you root out the problem in advance, but if there is going to be a problem later, being able to show, look, here's how rigorous we were. We've done this audit, we're spending lots of money, and we're trying to run these things down. So anything we did as a mistake was truly just that. It was a mistake. I think is very, very helpful and can be compelling. And then the last thing that I just want to touch on briefly, because this sort of dovetails with the point that I made earlier about taking concerns seriously when raised internally. I strongly encourage clients, again, particularly in the healthcare space, and particularly, if you're a hospital, health system, et cetera, or payer, if you've got an employee who's leaving, and this doesn't necessarily apply to every employee. If you have an employee who doesn't have access to key information or claims, it might be less of a risk. But for employees who are going to have relevant information, and frankly, it doesn't hurt with any employee, to pin them down during exit interviews in terms of, whether they had any compliance concerns, things of that nature. I mean, I always think this fits squarely in the category of you're better off to know, as I talked about earlier. I mean, there's always the risk you're going to end up asking the question and you get a laundry list answer of potential problems, and maybe you start to regret that you asked. But I still think you're better off to know. And it's just as helpful, from either standpoint. If the person says, no, there's nothing, and particularly if they're signing an exit questionnaire using that, that's not going to stop them from pursuing a claim later, and it's not going to be enough to cause their claim to get thrown out, but it's certainly something that can be used to impeach them later and to reflect that they were really trying to, bamboozle the company and get money as compared to being genuinely concerned about fraud when they could have addressed it. And I think similarly, if they do identify things, it gives a great opportunity for the company at that point in time to do an investigation or analysis, and potentially it is a real issue that got identified, and now you can solve it before it becomes much more significant and costly. The other thing is, figuring out if you're giving an employee a severance or a settlement agreement as they're leaving, figuring out the best way to protect yourself. So any claims that exist under a state or the Federal False Claims Act belong to the government, whether it's a state or federal government. So you can't get the employee to release those, but most courts will enforce a release of the employee's right to recover as a result of a claim brought on behalf of the government. And so what you can do is include language in the release where they waive any right to share in that recovery, and many courts will enforce that, and it's going to give you a lot of protection because it'll provide a disincentive for the employee to go forward because they won't have personal upside in it. So it's just another item that can be considered. And so with that, I know we're coming up on the end of the hour, so I want to thank everybody for attending. I think we covered a lot of material, and I know we were going a little quickly, but hopefully all of it registered, and certainly we appreciate your attendance and your time. And if there are any follow-up questions or comments, please don't hesitate to reach out to us, Brett or myself separately. We're happy to discuss. Thank you very much.
Thank you very much, everybody.